Most lawyers in Kenya are still conducting legal research like they did 10 years ago, pulling case laws from the Kenya Law reports, scrolling endlessly through the Kenya Law website, copy-pasting paragraphs into Word documents, hoping and praying that the president is just right. Now, I'm here to tell you that there is a safer way. There is a faster way. And it doesn't really require you to be a technical person. Now, you see, last night, I and Dr. Nelly Kamunde, who is a lecturer, an advocate of the High Court of Kenya, and a legal innovator, sat into a masterclass where we delved deep into how to utilize artificial intelligence to conduct your legal research safely and, most importantly, more efficiently. And this is that session. So stay tuned till the end where we share resources and key information that you can start utilizing today in your practice. Good evening, ladies and gentlemen. Welcome once again to another session for learning. Today we'll be talking about AI for faster, safer legal research. This is a masterclass for East African practitioners. We have our practitioners from Kenya, from Uganda to Tanzania. Today we'll be looking at the elephant in the room of legal practice. How do we actually utilize artificial intelligence in conducting our legal research, to do it safely, to do it professionally, and to ensure that we are compliant with our professional obligations? Today, I am joined by the intelligent Dr. Nelly Kamunde, who is an advocate of the High Court of Kenya, is a lecturer of very many years, and a legal innovator who will join me in exploring this topic. I hope that we will share a lot and learn a lot, and each of us will walk out of this session having grown as a practitioner. So without much further ado, just about to get started. You can see colleagues here. Just let them know we are about to get started. We will start at exactly 7:03. Before we begin, today we are doing legal research, and one of the tasks that you had when coming here today is to identify a legal query that you want us to research together using artificial intelligence, so that we can be able to demonstrate how to do it properly. For those who we have not made an acquaintance, we haven't had the pleasure to be acquainted. This is your first time attending Lawyers in the Cutting Edge webinar. My name is Robin Mothomi Mutiga. I am the founder of Lawyers on the Cutting Edge. This is a community of legal practitioners in Africa who are working together to understand how to navigate the terrain of the AI of the AI age. And today we'll be discussing the use of AI for faster and safer legal research. And before we begin, let me make 3 promises to you. Number 1, today we are going to learn 3 things. Number 1, we shall identify a mental model for where AI fits in legal research and where it doesn't fit. Number 2, we shall evaluate 2 tools that you can start using today. And number 3, we shall provide a framework for managing professional and ethical risk before AI works leaves your desk. That's the goal and the objective of this masterclass. What this session will not do: number 1, this is not a replacement for legal judgment. Number 2, this is not an endorsement for any tool as risk-free. That is not the case as it exists right now. And number 3, this is not a course on becoming a developer. This is working session on how to use artificial intelligence without it using you. So, your speakers for today, as I mentioned, my name is Robin Muthomi Mutiga. I am a practicing advocate. I am a legal technologist. I pride myself in not only teaching how to utilize AI, but also building the future of legal practice one workflow at a time. A bit of context behind me. I have previously founded a legal research platform, Sharia Search, and today I will be opening the doors and telling you the ins and outs of all technology that goes behind the building of a reliable AI research tool. Joining me today is Dr. Nelly Kamunde. She's an advocate of the High Court of Kenya. She's a lecturer at the Kenya School of Law. She's previously at the Kenyatta University School of Law. She is a legal innovator, and she has built and developed various products before even artificial intelligence was the big thing. So today she will be breaking down, as she would, for her class, how we can go about utilizing this technology as a tool. So one of us builds it, the other teaches us. So this is going to be a very, very, very interesting discussion. So this is the three things we're going to do. So we're going to frame, open, and understand the landscape of the East African research landscape. Number two, we are going to review the AI tools with a live demo. And then we shall review where AI can go wrong. We shall look at mental atrophy and how AI contributes to mental atrophy. Number three, we shall talk about managing risks. We shall do a Q&A and exact next steps to do tomorrow morning. So these are the 7 sections we're going to cover. I was covering the opening and the frame. My name is Robin. Thereafter, we shall have Dr. Nelly to go through the East African landscape, and then I shall take you through the AI tools, and we shall do a live demo on the questions that you may have. Again, if you have any legal query that you have walked in here today, please feel free to type it in the chat, and we shall utilize it as our legal query for today. After that, we shall go through mental atrophy. We shall go through what happens when artificial intelligence goes wrong. And then finally, we shall talk about managing the risks that come with this technology. And without much further ado, join me in welcoming Dr. Nelly Kamunde to present a landscape on East Africa. Please give her a round of applause as she joins us and begins the session for today. Welcome, Dr. Nelly.
Right. Good evening, everyone. I'd like to thank you, Mr. Muthomi, for that kind introduction. Right. So this is not going to be a theoretical class. First, I want to just start by thanking you for donating to us a good evening hour before your dinner, or I don't know, after your dinner. I'm very, very happy to see familiar names. Some of you, my students, and I've also seen one of you, my teacher, Dr. Mutuma. I'm grateful for your time. So I have some experience particularly in legal research. You can save the very hard technical questions for Mr. Muthomi. But I have a few points to share from partially something that was somewhat on the logic of AI. And this is my experience. When we start in first year, Miss Nelly Sophie, you're here. I think we discussed legal writing in first year. Most undergraduate schools do it in first year and third year. At law school, we do it as a practitioner's course for legal research and writing. We combine it with drafting. At the level of practice, if you're a diplomat, I think there's somebody who signed up here. If you're a legislative drafter in parliament, people from Kewo, you would find a library that has things related to the content that you normally work with. If you're in HR, you would take out from the content that relates with you. Now, for law, we necessarily take out legislation, gazette notices, subsidiary laws, and then importantly, we look at jurisprudence from cases. That is what AI calls corpora. In other words, it is the information that we draw from. Now, this is the thing. I'm going to use the analogy of somebody called Gerard. Gerard is an extremely convincing, eloquent, persuasive, all-knowing person. He walks around court corridors, he goes to classrooms, he's in the library. In fact, chances are Gerard will give you the exact answer that you're trying to find out. But there was one time when you met Gerard and he lied to you, or rather, he told you something that did not exist. The problem is he does it with such confidence, such eloquence, such grace that you cannot start doubting him. Now, the problem becomes that you do not have capacity like Gerard. He can read 10,000 cases. The human mind is not able to do that. And this is the problem we are calling hallucinations. We're going to talk about some aspects of regulations about it. But for now, the issue is how do you practically and conveniently use Gerard, because he's very, very useful. But then again, you can question him. So Gerard is the AI system that you want. The things that Mr. Muthomi is going to show us indicate that Gerard is very teachable. You can take him to class. You can go and find him a corner and tell him, you will only read this library. Don't read any other. Or you can tell him, anytime I ask you a question, I want you to only read this database that I have fed you. Or you can tell him to read Uganda law reports or Tanzania law reports or only Kenya law reports. This way, there is no chance of Gerard telling you something that does not exist. You can even tell Gerard some facts. For example, I was saying the oldest court was the Mombasa Law Courts, 1897. You can tell him that fact so that if he is ever tempted to go beyond that date, he can go back to his manuals that you have taught him and say, okay, this is a fake case. I will not produce it. So what, ladies and gentlemen, I'm saying is that AI is a query system, but it has more than the querying system that you can domesticate. You can even tell Gerard, don't leave my house anymore. You're going to only learn what I teach you so that he doesn't have opportunity to go learning other things, but he can speak to you. This is what is called the vector embedding and so on. He can use words and English language that you never taught him, but he naturally knows how to connect this and that. Right. So in East Africa, we have the official reporters. When it comes to legal research and writing, literally all the law schools, undergraduate and postgraduate, insist very carefully on the official reporters. So even without AI, we were very skeptical of going outside the official law reporters. Kenya Law Reports is, and I mean this nicely for all of us who are here, is the oldest, sorry, is the most highly documented, perhaps because of one thing or the other, because of how old the courts are comparatively and how much volume goes through. The judgments are from 2003. Yeah, I'm on, in case somebody has managed to share the slides, I'm just on the second one. The judgments for Kenya law reports that are digitized, sorry, not, yeah, digitized are from 2003. Non-digitized one predate 2003. What does that tell us there? If you get an AI report that has an EKLR number that is before 2003, you should question it. You should be very skeptical and say, okay, wait, this didn't exist before that time. We have the birth dates of Eastern Africa law reports. And from our training, we know that is reported as EALR. Yeah, EALR only existed between 1957 to 1975. All this is going to be available to you, by the way, in the slides. So if you find a case that is EALR 1976, let me say even 1977, that would be a problem because 1977 is the time that East African community collapsed. So there's what is known as a reporting gap. If AI gives you a case of that date, you question it. So I have compiled, alongside Mr. Muthomi, a set of facts which you can train Gerard and tell him, these are the facts of finding cases within the region. So you cannot report on this for the reason, blah, blah, blah. One other obvious one that I tried once, we're not going to do demos here. I think we've had enough technological, no, we'll do demos, of course, but not right now, directly for the, I wanted to search a Supreme Court case. And then I show you how one time I got a Supreme Court case of Kenya that was 2009. We know that's not possible because all the Supreme Court cases start just towards the end and beginning of 2011. So chances are that is a fake case. Right. So that is about jurisprudence. Let me say something, jurisprudence in terms of case law for the region. Let me also say something else about legislation libraries. So here we have the Constitution, we have Acts of Parliament, county laws, we have subsidiary legislation and related or equivalents in East Africa, ULII, that's for Uganda, TZLII, that's for Tanzania. When I say East African Commonwealth, our examples for this session are those three countries. They have all reporting dates. There's something we call legislative markers. In other words, there are characteristics that form the official reporting of a legislation. If you were to download a legislation and it gives you a report that does not have a gazette notice, you have, ideally for everything Gerard gives you should smell a rat. But now you have the obligation when it has signs of obvious lying that you should go and check. There are some of them that are a little bit obvious, like the penal codes, it's Cap 63. There is the amendments that are usually extremely sensitive, at least in my experience, where you have to go to the Gazette notice reference and know that, okay, this particular provision, I need to cross-check it with the actual national reporter, Kenya law or Uganda law, and make sure that it's not lying to me. I also have to say that for legislation, AI has the tendency of summarizing for you. There is an assumption that it has been trained to make your life easier. Sometimes AI, for example, the language that ChatGPT gives you for the exact same question in law and what Meta gives you for the exact same question without you giving it instructions of sound like a teacher, sound like a professor, will vary. That is dependent on the training that it has been given. And the training that it has been given serves the, can I say, the capital interest of the company that owns it. If Anthropic realizes from its research that people within a certain region in certain topic would prefer a friendly tone, then it will give you a friendly tone. So there is some kind of reasoning and value judgment that it imposes there, which may diminish the value, diminish the objective content of the law. So when you're looking at legislation, you have the obligation to tell it, give me verbatim. So the training prompts that I have prepared and more, they're just literally samples that you can develop more and more to give them the kind of intelligence that you need. The official citations, which I have here in the slide, and I will also send you in the starter pack, give you a hint of the of whether or not a document, not document, sorry, but a case is real or fake. The digitization date, the digitization facts are very, very useful. Why? AI can only draw from what exists digitally. In fact, what exists on the web somewhere. In other words, ChatGPT does not have it has limited, let me say, has limited capacity to know what exists in hard copy. So the reporting gap that we call in East Africa between, did I say 57 to 77, when the East African community collapsed, most of those judgments are hard-coded. They are in print media. They are not in electronic media. And maybe this is something people in the spaces concerned can think about. If we make our own Victor and our own SUVAs, I'll explain, those are curated digital AI databases, one for Brazil, one for India. It will be very important to collect everything that exists and make sure that it is there. Kenya Law Reports has done, I guess, a good job, because even their gazette notices starts from the 1800s. So I don't know whether all the stuff is digitized. So the point I'm trying to make here very quickly is that the reference and the timing of digitization will give you a hint as to whether a case is real or fake. Now, apart from what we have in the starter pack, you can have a conversation on a case. For example, if you ask Gemini to tell you a case on unfair termination, and it gives you a case that predates the establishments of Employment and Labor Relations Court, you can train it and say this cannot be because this court did not exist before 2010, or this case cannot be because the act was established on a certain date. Now, lawyers are very well placed to understand generally how the law has evolved over time. And you can even defend it because cases have given so many hints. We'll go back to cases in a bit. So the point there in slide number 7 is AI can only search what is visible and not what is invisible. Let me say something about semantic searches and the caution that we should embrace as advocates who use AI. Now, earlier on, I was talking about keyword searches. If you look at any textbook, well-written textbook, secondary resources, treatises, you go back, it gives you words, then it gives a page reference. When we were learning print media law research, we could find out a topic like I don't know what, breach of contract. So it's a simple example. And you realize that in the index at the back, it refers you to page 15 and 20. Now, AI has a way of understanding alternatives to even breach of contract. They could have varied. Oh yeah, here's an example. So let's use the word wrongful dismissal, unfair termination, and constructive dismissal. These are not the closed words that we could use to understand wrongful dismissal. Semantic meanings that is derived from AI can expand this endlessly because without going too much into the detail of it, vector databasing uses a variety of numbers to tell you how closely meaning and how distantly meaning a word is. So it can go beyond the words that the act or the case has used to give you varied meanings. This is a good thing. The problem is the value judgment that it can place for you. It can replace your own sense of reasoning and give you something that may be a little bit variant. And we know that sometimes the precision of words in our law has even been litigated about. So this is a point to be very careful. The semantic preciseness varies from AI system to the other. I know I don't think legally I'm allowed to say which one I have found to be good. Let me just say they vary. If you look at, you can use a topic you're extremely familiar with, and you put it in Claude and Grok and Gemini and see the responses they give you just because of the reality of this varied. This is how AI understands the law. This point here, I wanted to just tell us that AI relies primarily on this is not me saying, it's out of research, primarily on secondary databases. The key ones that we have, most of them are, some of the best ones are paid. Hein Online, Gisto, SSRN, some of them we used at in the universities. The training, unfortunately, all the way up to Google Scholar has a reliance on can I say global north or non-African digitization? Why? Because the years of from the time when the internet came in, African things were not as documented as they are right now. I don't have the numbers or the skills, but it's on the increase. But from the beginning, that's why I was trying to give us, that picture of how old the court system, how old the court storage of documents is, just for us to know that we will obviously miss something because of that gap of digitization. Government records, the same. So the university repositories are a good source of it, but remember, these are secondary sources. In law, I think for most discipline, we categorize primary sources and secondary sources. Primary sources have higher weight than secondary sources that we have. So most of the time, one thing you can note is you risk a lot of copyright issues for the fact that the AI models are trained using secondary databases. It is not unusual if you run what we call in law the Turnitin or safe assign report, and you realize your work is sounding like a dissertation in the University of Nairobi. That is a reality of copyright that one has to be very careful about. If your work is sounding extremely eloquent and good, without even being a document forensic analyst, you can tell you can know that there is a risk of copyright because of the training of that the models have had before. Let me be honest now. Time for the truth. I've said a lot of things. The speed and efficiency gains of using the AI are mind-boggling. If you have tried to ask a question in an area that you're familiar with, you type in some confused data, type for me a message to somebody without sounding rude and tell them that I can't make it, yet I don't want to make it. It gives you the exact beautiful words that you can use. If you tell it, help me establish what the Court of Appeal has said on this issue and this issue, you go and confirm on EKLR, it shortens your time and you begin to trust it, and it is efficient. It is most of the time right. So the speed and efficiency gains are not things we can pretend we don't like. So the question we want to ask ourselves is how do we capitalize on this without risking? So we need to find out how to use safe, accurate, and risk-reduced detection. Most platforms can give you no, they can't give you, but AI tools can have statute tracking. Before ChatGPT would tell you it has cut-off dates. I don't experience that so much. It's up to me to go and check on there's this legislation tracker for Parliament and know where a legislation that is being debated has reached. Sometimes I have domesticated some tools, so I go and tell him, you have not checked this bill, it has reached in this state. Then it says, okay, yes. Then I ask the same question again, then it gives you a correct answer. So the issue of cases is very serious. Overruled cases sometimes come back as not overruled. So that is something else that in the startup pack, I kind of try to juggle around how do we deal with this. Then we have general hallucination, safeguards, and audit trails. So every research session, once you log in, you can maintain the discussion. Also, this depends on whether you're on premium or whether you're on the free tier. Sorry, I'm really wrapping through because I've eaten my co-host's time. Now, the leading AI research tools, as we speak now, with all the hallucination securities that I was talking about, LEXIS is the strongest for Commonwealth, for common law. Westlaw also has common law legislation, and it even has newspaper reports from a very long time ago for fact checking and all that. LEXIS has something called Protege, I believe, and then there is one for Westlaw, and then there are those ones that are domesticated. These are very expensive. If your firm has them, it will be extremely useful, extremely good learning experience to go and exploit them. If you're in the university and academia, campaign that you access Protege and LEXIS and all associated AI platforms. The problem here is that they do not have strong Kenya and Tanzania coverage. They also don't have, very important that I didn't say earlier, the nuances we have. If you read Supreme Court cases where you feel like the literal content of the law would have gone this way, yet it goes that way, it is because Kenya in so many ways follows what, and I'm really scared I don't go into a lecture, follows something that is some kind of American realism, which simply says that the law is supposed to service the populace. It's supposed to serve the public. And if it doesn't serve the public, it's not good law. So the posited law has been thought about based on our history, our context, our land issues, our election issues. And therefore, the court have the liberty to make translations and interpretations of the law that are conducive for those particular purposes. Protege will not do that. Why? Because it is trained on a different way of how law is posited. That's a problem when you are getting output for purposes of even making arguments in court. So human verification is very important. Let me say something also, which I have talked about. The East African reality is that we do not have the citator. The citator was an AI without being called an AI for Westlaw and Lexis. So Westlaw, they call their citator Keysight. Shepherds is for Lexis. These are clever little animals that go through the entire database of their Commonwealth archives, and they tell you that this case has been overruled, it's been set aside. They do cross-referencing of cases that mention the same doctrinal aspects in a very good way, so that the lawyer now sits down and say which is the best law to cite for the court. We don't have that in Kenya law, and definitely not in Uganda and Tanzania. And that is something that now we are filling in the citator gap with AI. Yeah, which is hallucinating for us because it will work based on how it was trained. You can query the citator gap if you have rights, and you realize that there's a huge super base or an Excel sheet that has dates of when a case was overruled and overturned and so on and so forth. So it has more transparency than AI would have. So this point here is, if you are in the capacity to do that, domesticating your own citator is very important. I've tried that in some things I'm doing. You see, like the way you build your own folder with a number of cases that you're working on. For example, I'm working on a manual on wildlife crime, and I have built cases that touch on wildlife crime. But now, before AI, I couldn't take those cases and search across them. Say I want to talk about wildlife possession, illegal wildlife possession. I had to open one, Control F, then I find it, talks about it, and so on. Now I can collect all of my 50 cases, put it on Claude, and then I give Claude instructions of what to do specifically with what I've fed it on. My colleague will talk about Notebook LM that does even a better job for that. So second last point very quickly, risks, ethics, and responsible use. Now, having hallucinations is, we used to hallucinate before we learned AI hallucinations. You could go to court, you could be in class, you could be in an exam or oral exam in the School of Law. You do not know a case and you literally hallucinate one. What has happened now is that the word hallucination has become kind of elevated because of the scale of risk that it poses. The court practice directions on AI of many countries, including ours, are expressive forms that say there is a big problem of fake data and fake cases, and there is a high risk of, a scale of negligence than we have never seen before because of AI. So recklessness was not allowed, professional negligence was not allowed. But now we face a situation where that is likely to be on a scale that we have never experienced before. This is what the practice directions and the policy data are doing. The evidence, and I am careful not to go into a case that was recently decided, the evidence of the negligence of an advocate still stands on the laws as we knew them. Some countries, like the Caribbean practice directions, have given more stringent rules on anti-AI when you're writing affidavits, when you're writing evidence-related information. So they have said do not use. But again, they would need serious forensics to be able to pin down an advocate and say, okay, you drafted this affidavit using an AI. So it's more of an expressive function of the law. It's more of a reassuring way of saying, let us use AI, but it can overwhelm us. So we have laws that tell us what could go very badly if we misuse AI. We can look at them later. Now, this is just a little bit issue of confidentiality that I figured out. When you're using Claude, that is the one belonging to Anthropic, you have the alternative of toggling off the stored data. You could have, like the way you search incognito, you have ghost searching, ghost storage information alternatives. ChatGPT also has those, and I would encourage us to exploit them. So I've written there settings privacy, help improve Claude, etc. You could also use a prompt. I've tried that where I've told, tell me how to improve data protection, or you, for everything that you upload there that has people's names, you could always instruct that you change it to John Doe and stuff like that. You'll forgive me for talking very quickly. The tools that exist, internal, external, and then there are many that are free. Sorry, this is a point. It's really the last point I'm making, and then I invite my colleague. If you're a builder, if you're working on a tool, I've had some experiences or rather conversations where they're warning. I have built a tool, which is, where is it? That one. It's free to use. There's no charge for it. You can exploit, you can comment on it, you can reach out to us so that we improve it. So this is a constitutional research tool, and I'm looking at case law and trying to annotate it. So the database that I'm using is controlled. In fact, if you search for it, it gives you red light, green light, and yellow light. If you see a red light, it's bordering on legal advice. If you see a green light, then you can use the information. We have vetted it. Now, a Victor is a very high-level, expensively built version of this in Brazil, and Suvas is one for India. So this is still ongoing. One of the things that is happening is that builders are using databases that exist. I'm looking for that slide. Databases that exist to, just a moment. To develop their own tools. So there's something called robots.txt. It simply is saying that while you're using EKLR, please leave it free for other people who do not want to build tools to use. Because if you scrape the base, if you go against the copyright, which means you take out the entire case, including the annotations, you will breach copyright, and that can be a serious problem. There are data protection laws that could be breached as well. So the idea here is for and I'm a big AI optimist. I believe we should build our own proteges and case texts and whatnot. So it's very encouraging to see many tools that people are working on, and it would be very good to collaborate. However, these are the cautions that I've come across of what to take care of if one is building tools to domesticate for selling, for using, and so on. Everything I have used in this presentation is free to use. The EI compliance master pack for Kenya, Uganda, and Tanzania that I will give you, which has prompts that you can feed into your domesticated thing, is free to use. You can sell it, you can monetize it, and so on. I will stop there, and I will hand over to my colleague, Mr. Muthomi. My apologies for taking too long.
So much, Dr. Nelly. Again, apologies for the technical hitches we've had. Yes, let's please give her a round of applause for what she's presented. She'll be back here talking about mental atrophy and what it means to actually use AI instead of letting it use you. So without taking much more of your time, I see we are almost completely out of great, brilliant. So as I said, my name is Robin Muthomi. I am an advocate of the High Court of Kenya. I am a legal technologist, and I love building AI tools. I am on a mission this year on building the law firm of the future, tech native, AI enabled, and workflow fast. So today I'm going to take you through the demo. How can we actually utilize artificial intelligence to conduct legal research? So very exploring how to, what legal research is and what areas do we apply, where do we apply AI? We don't apply AI everywhere. So there are three tasks that go with legal research. The very first one is retrieval. You have to find the information that answers the query that you have. So first of all, you have to retrieve. The second thing is you have to reason. You'll find a case law, you'll find a statute, you'll find a subsidiary legislation. Does it actually apply to the facts? So the second part of legal research here is retrieve, then reason. And then finally is the remembering part. And you'll agree with me that most practitioners, most firms that are operating within, the confines of practice that requires research do not have workflows around remembering. And there are four ways in this day and age that you can conduct these three tasks. That is retrieval, reasoning, and remembering. The first one is the manual one. As my co-presenter, Dr. Nelly, was talking about the Makerere University and how at the level one, that is how you would be operating. You'd be walking either to Kenya Law or into a library, finding the case law or the answer to your question that you have manually through keyword search, and then you'd read it and annotate it, and then maybe you'd write a memo and file it to be remembered later. Now, there is the second method of using artificial intelligence to now accomplish this task. As we have said, there are very many benefits to using artificial intelligence to conduct your legal research, but there are very many pitfalls as well. So you have to be very, very careful. How do you actually conduct your legal research? Now, the plain AI method is the absolute wrong way to go about conducting your legal research. And this is the problem that most practitioners are making. They are basically just going to ChatGPT, Cloud, Gemini, Grok, whatever it is. They are typing in their query and they are getting an answer. This is where hallucinations come in, because while you're using the plain chatbot, what happens is it's generating the text. It's remembering or trying to retrieve what it was trained on. So what that means is initially, once you type in that query, you will not get a reliable answer. Gerald will not give you a reliable answer because what it will be trying to do is remember something that it was trained on. And more often than not, it will make up very, very truth-sounding citations that do not exist. So the plain method of going to ChatGPT, that is the wrong method. The second way you could do about it is using a guard-rated AI. This is where the AI only answers questions from a set of corpus of documents. Okay, what does this mean? The AI does not generate the answer. In this instance, its work is to retrieve what it thinks is relevant through a semantic search, which I will show you visually how it appears. So in the guard-rated AI level, you would upload your own documents, or you would have AI reason and read the documents that you have and answer from that. But you still can see there is nothing you can do to remember. And then the fourth and final system that I'm going to show you is one that I have custom built for my firm. It is system level AI. It is automatic, it is multi-source, it's verified. Once you retrieve it, it's reasoning, it will have multiple agents that are critiquing, debating on the interpretation, and actually doing a citation audit. And then finally, and this is the real power breaker, this is the real leverage, the vault grows with every query. And I'm going to show you exactly what I mean by that. The level one, this is how you'd approach it. Number one, you'd go into the morning, go to the library, travel, pull out the books, or you would open your Kenya Law portal, switch tabs, and then you'd use keyword search to find the right phrase for your legal query. After that, you would read it and annotate by hand, one case at a time. And then eventually, maybe by the third or fourth day, you would have found the answer to the question you have, and you have filed it so that you can use it. But you'll find that in most instances, you'll never reopen it. So this takes 2 to 3 days. It's fragmented because the sources are scattered. It's siloed because you do not have institutional recall. You don't know what the associate before you did. You do not know the colleague next to you, what have they done. And then finally, you'll always find that you're missing cases. You'll find a high court case that is relevant, only to find later that it was turned down by the Court of Appeal. So how does level two look like? Level two looks like exactly how most of us are using ChatGPT. You'd go to ChatGPT like this. You type a query, what principles guide the stay of execution pending appeal, and then it will generate text. Right now, it will go to the internet and do searches, but most of the time, it is just generating texts from its training data, and this is where we are finding the hugest problem with hallucinations. There is a scholar who has been tracking how many times AI has been found in court to have hallucinated, either by judicial officers utilizing it, either by practitioners, either by individuals who are self-representing. And he has recorded over thousands of times where you find that it is happening all over the world. And the problem is because most of the people are using plain chat GPT like this to actually perform their legal research, which is wrong. Or most of the time, it has no guardrails. Okay, so what is the third level? Let me show you what level 3 looks like. Now, level 2 was where you type into ChatGPT. Let me show you what level 3 actually looks like. This is where I would use a tool called Notebook LM. I teach this tool to all practitioners that I find, all law students, people who are doing their master's thesis. This is a truly, truly powerful tool that you can utilize because it does something exceptional. Instead of trying to remember where or remember your answer from its training data, it actually retrieves the answer from the sources you provided. And it uses something Dr. Nelly mentioned called semantic search. This is where text is, stored in a 3D vector database. Let me show you exactly how it looks.
Yes, we can.
Brilliant, brilliant. So this is exactly a 3D model of what a vector database would look like. As you can see from the screen, they are very tiny dots. The orange dots are case laws from the Court of Appeal. The yellow ones are case laws from the Supreme Court. The blue ones, you'll find there are very few. They're from the High Court, and you'll have statutes, cases from the ELC and ELRC. So this is what a vector database looks like. It's a 3D space. That means we can just go through it like this. We can zoom into it like this, and we can review it. Individually, what happens once you put case laws or any kind of unstructured data into a vector database, it is structured in a way where things that are, closely meaning, things with closer meanings are placed together, while things that are not related are put far away from each other. And as you can see, there are clusters here. There is one for deceased and estate. There is one for land and suits. There is one for stay and execution. So once you have your data in a vector database like this, what happens is the AI will go look for a document that is close to the query that you have given it, and it will help you identify the sources very quickly. For instance, here I could search stay, and very quickly it will demonstrate what goes around when you do semantic search, stay of execution. So as you can see, it will highlight the specific cases in this vector database that are specifically around stay of execution. And this is how you can utilize AI to do more reliable research, hallucination-free legal research, because what happens is that the AI is actually retrieving the text. Let's use AI to retrieve and not to remember. That is the key thing. As you see, whatever is highlighted here is cases that specifically touch on stay of execution. Now, let me show you a tool that you can start using today. Notebook LM, as I said, is a tool that anybody can use. It helps you conduct legal research very quickly. And as you can see, there are 3 tables here. There is the sources table, there is the chart at the middle, and there is the studio at the far right. So this is where you'd add your sources. If already you know what you want to research, if you already know if you're maybe, for instance, doing a tax law question, you can go find all the statutes and regulations around tax and have them structured in a notebook like this. For instance, I have one for tax here. And very simply, I'll just come here and ask a question. So this one is full of the Income Tax Act, as you can see, the Miscellaneous Application. This is a case law, the Stamp Duty Act, the Tax Appeals Act. You can add up to 300 sources for the pro version. You can add up to 50 sources for the free version. So there's no excuse, and you can start using this today. So if you already have your citations, you already have the sources that you're relying upon, you can just start add them. If you do not have them, you can utilize Notebook LM to actually help you find these sources. So you'd come here, do either deep research on the web, or you could do fast research. Of course, it will vary on the time and the depth of the research. You can upload YouTube videos, you can upload links, you can upload documents in your drive, you can upload copy texted text. And what happens is once you upload these sources, you can start asking questions upon the sources that you have, given it. So every time it answers your question, that answer will always be guided from the sources that you have given it. So in this instance, it won't be answering per se, but retrieving. So for instance, how can tax preservation orders be set aside in court? I'll provide that. It will go to the sources here. It will read through them. It will find the relevant paragraph that answers this specific question, and it will give me an answer. Under the Tax Procedures Act and judicial precedent, a tax preservation order which prohibits a person from transferring or dealing with funds belonging to a taxpayer can be set aside or discharged to the following legal avenues. And it will give you them, and it will cite the specific session. And even much further, it will go to the specific paragraph where it got that answer. You see? So you can very easily see the reliability and the transparency that this comes with. I teach a lot of people AI, and most of the practitioners I talk to, especially legal practitioners, always they always pose this question. Nobody is talking about hallucinations. That is, people who are teaching tech aren't teaching about hallucinations. And the reason is because there are methods to go behind it. Among it is semantic search utilizing a vector database. And this is basically what Google has built for you. You can start utilizing today. Okay, so this is Notebook LM. This is what you'd start utilizing for instances where you have the sources, or you can help you find the sources. So for that question we asked, you can ask a question again and it will give you the answers. On the studio here, you can do you can create podcast videos, you can create mind maps, you can go in depth into your sources so that you can continue delving deeper and deeper so that you can understand what the query that you have. Now, my second demo, this is a custom tool that I have built for my own firm. This is a tool called the Legal Research Brief. The Legal Research Brief allows me to do various things. So among them is having this knowledge management system, this knowledge base, this corpus. It allows me to continue growing and growing the information that I accrue. So it's very simple. I'd come here, type in a research query, maybe just like the one we type to ChatGPT. It would have actually 6 concurrent agents doing specific things. One would find the statute and reference it specifically. The other would find case laws that interpret that statute. The other would read and review, and finally write. One will check citations. So at the end of the day, you would have the very first draft of a memo for a legal query that you have. So this might take some time. So as you can see, it has identified specific case laws, both online and within my vector database. And every time that I do a query, all these sources are added to my vector database. So I can just tell it continue. I can give it context so that it will go through, read all these case laws, and very slowly or very quickly, depending on how you need it or how straightforward the question is, it will give you a memo that you can review. As that is happening on the background, this application also allows a firm to do something else. it has something I do called the daily briefing. Every single morning, it goes to Kenya Law, finds cases that are relevant to me, my practice, depending on the queries that I've asked multiple times. It will give me a summary of those, and I can very quickly, continuously learn what the courts are putting out. So it will give me a case from the Supreme Court and give me the summary. I can actually go back and read it from Kenya Law directly. It will give me a case from the Court of Appeal, one that I can review, a key one depending on the queries that I've given it. It will also tell me about incoming legislation, and very quickly, every single day, I can find myself reading and improving. Instead of trying to find the law, I always have something that is informing me and my team every single day. So that's the second feature. And the third and final feature is now the ability to archive all this data in a vector database that you can search semantically by meaning and get answers from the searches that you get. This is something that every firm should have, because whether you're the one doing research or another team member is doing research, you contribute to the brain, the second brain of the firm. And in 5-10 years, you shall have a knowledge management system that grows with you, that understands the queries that you have, and that you can continue growing with. So very quickly, that is just a demo of how you'd go about utilizing AI tools to conduct your legal research. We have looked at the plain way you'd go about it, using Kenya law or using your standard law books. You'd use the standard ChatGPT, which generates and is prone to hallucinations, or you could have something that is tethered and only answers questions from what you actually request. And then finally, at the highest level, you can have a tool that grows with you, that continues to grow with the firm, that can continually improve as you use it. So, that is what I'll be talking about mostly. I hope you have been able to see how this tool can be utilized in a firm. If you have the intentions of having a tool like this custom built for your practice, among other AI tools that do legal research, that do intake and drafting, that does various other things, I'm available for consultation. I'll be offering strictly 10 consultations for those who would be willing for the coming month. I'm sharing the link to the chat right now. You can book your consultation. I'll be taking 10 consultations for the coming week. And if you'd want to understand how to start building tools like this that do various administrative functions within your firm, or an AI operating system within your firm, then that is once we get to that consultation, that is what we'll be discussing. So you can click on the link, pick a date, either in the morning or in the afternoon, and then we will discuss and explore what tool can we start using today. You can check the link in the comments. Just access it. There are only 10 slots. Pick a time that works best for you, and then we shall engage later. Now, I shall welcome back Dr. Nelly to conclude on the actually using AI and not letting it use you.
That is called EA Legal AI Compliance Master Prompt Pack.
Yes, we can see it.
Okay, so I will share this document. Mr. Mudomi, you can share a link for those of you who are interested. I will be happy to send it. Put your stuff on the link that Mr. Mudomi will send. I'll just insist very quickly that this is just a base. You can convert it to your own use. You can increase it, decrease it. In case there are errors, of course, on it, you can change them. I'll take just 3 minutes. I would like to thank you, the people who are still with us, who have been patient throughout. I want to say something that is extremely important to me, that is extremely important in the use of AI. There are all these, can I call them prophecy of doom about the effect of AI. If you have used, which one do you use to write emails? Something like Gemini, consistently to write your emails, all you do is click enter for a week. I don't know about you, but my experience was extremely scary. I felt extremely lazy. I couldn't settle. I was angry to write the email myself. I've also had an experience where I had a very short preparation time for an interview, and I used AI to prepare for the legal content. It's a very new area of law, a very upcoming area of law, and I didn't have time. So I was, instead of going to the usual, you go to the treaties, the conventions, you look for the laws, you struggle to get the answers, you write your notes with pen and paper. I had a very short time. So I read through and I had this false impression that I was familiar with the content that they would ask. When I did the session, the interview session, I realized that I could barely construct the content from how I had read it. When I share these experiences with people and students in class, they tell me genuinely that they feel that way. Why? Because there is the idea, we don't feel it much. We are not taught psychology in our training, because the mental muscles for talking, thinking, and writing like lawyers almost appear, like automatically. We don't think about it. We just realize we've changed. We realize we have lawyers that we like. We have favorites and not favorites. I'm looking for my slides, ladies and gentlemen. um, and that becomes a very big problem when we are trying to ask ourselves what happened. So the thing I would say, even in class, I try to adopt a very liberal way. And let me correct, by the way, I used to teach in Kenya School of Law and KU. At Kenya School of Law, I'm still adjunct lecturer, but KU, I'm no longer staff. So I personally adopt a very liberal way of teaching now, because either you do it, you disallow AI, but you have no way of supervising who has used it and who has not used it. So we have to think of new ways of being relevant in classroom. But I always tell people to measure themselves from time to time so that they are able to answer a closed book bar exam, so that if you go to court and the magistrate or the judge is asking you a question, you're able to vocalize it while looking at them in the eyes. If you use AI for too long, I am not lying to you, this could become into disuse. History and evolution has taught us lessons like that, like the muscles and the energies we don't use are going to become atrophied. Now, we deal a lot as lawyers with argument construction. We do analogical reasoning all the time when we are comparing cases from this to that. We listen to client interviews and we handle ambiguity of facts. This person, witness A says this, witness B says that. All of them are saying different things, and we have to settle down and say, which one should I pick out? This activity of physical meeting, physical discussion is something that has to be done by a human being, particularly in our world where you don't always expect all witnesses or all people you relate with to join a link online. You meet with them, you shake their hands, you change language, you speak in mother tongue. These are all extremely necessary tools for the legal practice, for the lawyer's life, wherever they are. A diplomat also has to, engage physically in different ways without using words. And that's the limitation, I would say, of AI, in my opinion, where we are not supposed to think of cognitive, communicative text as the sufficiency of professional existence. There's something beyond that, and we can't let that leave us. I'm an AI optimist, but I'm also a strong supporter of creating a very important balance. So if you're in a law firm, if you're in a classroom, if you work in a legal other setup, it is very important to try and create the discomfort dimension, either as yourself or as a leader of a team. So you first look for ways of creating tampered tampered discipline. Let me just get to the relevant slide, my apologies. To tamper the discipline of using AI. One of the rules I would advise is the first draft rule. Every time you have a legal problem, I have this thing I call pen and paper or pencil and paper, and you try and think common sense, what makes sense, what doesn't make sense, and what are your obvious questions. If you open the AI, it will guide and suggest your reasoning, and you're most likely going to take that path all the way to the end. I'm saying this particularly because a good number of signups were from students. So it's very important that even when you get an exam question or a test or a project work, you sit down with your teammates or you sit down in your law firm with a client and you think verbally, what is it that could come out of it just by our five senses. Then you have something I've called blind research sprints. So once a week, I mean, a team, if you have the advantage of being in a team, you have research that is non-AI automated so that people can preserve the reality of it. At the beginning, we had technical challenges. And one of the things I was saying is that what would we do if we were just without these slides or we were just us in a circle in a field? Would we be able to still effectively communicate? So it has to be possible to work with and without AI. Workflow could also be built without too much reliance into tools or having backups. I think elections in Africa are the perfect example to think about when this is done. So technology is important, it's beautiful. We are existing magically in the fourth industrial revolution and we want to be here, we want to participate. As I say, we were not there when they were making the wheel, but we're here now. So the question is, what is it that we can use and what can we do so that it maintains that balance for ourselves? So one of my teachers for legal writing told me that once you're done, always print it out if you can, and then you read just the paper yourself. If you can, vocalize your oral arguments because they will tell you how it sounds in a human voice for a human ear. AI free zones, if you're in big companies, could also be useful. You're in law firms where you say, okay, we are not using AI, we are just thinking by ourselves. Because believe it or not, the need for efficiency and speed is extremely addictive, and that is for all of us. We are all prone to thinking like that. That was the end of what I wanted to share today. And I truly hope that we've been able to engage in a way that is useful. It is my belief that the team that has braved the evening, even past the time we had promised, will be with us even in our subsequent training. If you feel excited to do that, you feel free to share the word about lawyers on the cutting edge. And hopefully in the future, we will have a certificate course. We are encouraging you to sign up when that time comes. Thank you very much. I appreciate your time. God bless you.
Okay. Thank you so much, Dr. Nelly, for your time. Thank you each and everyone for taking the time to be here with us until this late hour. Just to remember, if you want the PDF that Dr. Nelly was talking about, there's a JotForm link. Just fill it and you'll receive the PDF in your email. If you want a consultation also, you can find the link in the comments. You can just fill the link and then you'll be able to get a free 30-minute consultation. Before we conclude, I just want to request if there are any questions, we'll just take two if there are any at all, so that we do not take too long. And thank you again for joining us. The recording will be shared via your
brief. I got interrupted when you are discussing about this thing called vector database, the 3D vector database for doing semantic search. And you are doing this illustration using notebook LM. And one side, there were the sources, the middle, and then the studio, the other side. How did you say we can use that to achieve the 3D vector database semantic search so that we don't just fill the system with the sources we have, but we also make the system itself to look for sources?
so much, Dr. Gook. One more question. I think that one is directly directed at me. Yes, Rose.
Hello. First of all, that was such a wonderful presentation. Thank you to the both of you. I am actually very surprised that there is such huge development when it comes to legal technology building part, and specifically on that. Now, when it comes to, we understand that historically, like lawyers have been very conservative about adopting legal technology products because there's so many risks involved, and especially when it comes to how sensitive the client data is. So now when it comes to people who are already building, how can we how can we solve that from the technical bit of it, apart from the DPAs that can be signed and all of those compliance measures that can be taken? What technical mechanisms can be taken to ensure that this client data is protected from breach?
Let me proceed with Dr. Oguk's question about Notebook LM and the vector database. So what I was able to demonstrate, Daktari, the 3D view that you are able to see, that is a tool that I have built custom for my firm so that you can visually be able to see the vector database. You can see the individual points within your knowledge base, and you can interact and ask questions with it. That is something that I built custom for my firm, and it's something I built custom for other firms who are practicing law. Notebook LM basically has that vector database. It answers questions through semantic search, but there is no actual way of being able to create or visualize the data that you have apart from one. Let me just allow. Yes, there you go. So you can see it now, isn't it?
Yes,
Okay.
this is clear now.
Okay, brilliant. So
Yes,
once you upload your sources here, as I said, you just come here, upload your sources. If you don't have any sources, you can either search on the web, do deep research on the web, or do deep research on your Google Drive. Or you can upload a document here, you can upload a YouTube video, you can upload a link, you can upload your drive. Once you do that, that data is already embedded and stored within the vector database. You might not be able to see it. What I did is within my farm, you can actually see it. But that is how these documents are stored. So that once you ask a question, it does semantic relations and finds the exact paragraph that is most closely related to the question you ask. So that once it answers, so that once it finds that paragraph, it can answer your question with that context. However, there are other ways you can utilize this tool to visualize the content here. And this is where the studio becomes very, very powerful. I individually, Daktari, while I was in the Kenya School of Law, I utilized this tool a lot. I would come here, upload my conveyancing procedures. I would create an audio overview. It would run for 60 minutes. I would have it on my ears, just listening on conveyancing transactions the whole day. It can create a slide deck. It can create a video, semantic video, a video that you can actually visualize and learn. It can create mind maps. So especially for students who are learning and who are growing, you can utilize this tool as an analysis tool. You can create flashcards, you can create quizzes, you can create infographics that assist you to learn more and more. So if you'd like to visualize how the semantic relations look and how the knowledge graph looks, you'd need to do it custom. There are tools that you can utilize to build it, but this is the simplest tool that you can start using today without any technical know-how. Now, the second question which came from Rose is it. Rose, I believe that you are a builder of this technology like I am. So how do you go about ensuring that the tools that you are building, the solutions that you're creating do not, do not create a situation where your clients are breaking their professional confidentiality and their obligations? What I would advise any builders, and I'm actually trying to speak to as many legal practitioners as possible so that they can actually start building these tools. If you are a builder, this is the things that you should do. Number one, if you can be able to build tools that run locally. If you can build on top of LM Studio, if you can build on top of Olama, if you can build on top of the exact APIs where you can get a zero detention agreement, then you can really help your clients and be very, very sure and secure the tools that you're using do not infringe upon their professional obligations. So first thing, think about building on top of tools that can do on top of AI that runs locally on your devices, because there will be no risk of any data being breached. There will be no risk of any data being used to train the models, because the data lives on your computer. If you can find a way to build a tool on top of Olama or LM Studio, or train your own models that can run locally, or use Gemma from Google, which allows you to run local models on your device, on your phone, then you can do very amazing things. Number two, utilize the API, especially if you can get access to enterprise API. They do have zero data retention agreements that ensure that no data actually is retained. If you're not a builder, number one, do not use a free tool. If you're using a free tool, your data is the cost. Number two, if you're using a paid tool like Dr. Nelly has mentioned, for instance, you're using Cloud Pro or ChatGPT Go, you need to go to the settings and turn off training on the data. You can ensure that your data will not be trained on. But I recommend using an enterprise platform. I recommend for practitioners who are practicing within areas that are very, confidential, risky, either use a local model or use an enterprise model like Cloud, which costs $25 a month for a minimum of 5 users. And I think with that, I've been able to answer the question posed. I think we shall conclude the discussion from there. We shall share all the recordings as well as all the slides and the resources via your email addresses. Please, we will be sharing a feedback form. If you found this useful, please fill that form and let us know what you'd love to learn more, what you'd like us to cover next, because we need to ensure that all practicing practitioners in the East African region are competent to use these tools. So without much further ado, have a lovely night and stay guided.
Can we get the recording?
Yes, you shall receive the email with a link to YouTube. So you'll get the recording for sure.
All right, thank you.
Sasa. Karibu. Good night, and have a lovely evening ahead.